Yes.
Steps taken upon the private respondent as per the last order. I have filed one additional affidavit. It is regards to respondent number 4, 5, 7, 12, 20, 23, 26, 27, 28, 30, and 33 losses.
ये DB. Which item? Okay. Item number 1. I thought he's taking a German. Item number 1. I have not even called. I thought you were taking a German.
Sorry. I'm sorry.
Yes, come again.
Sorry.
Yes.
As per last order, I was supposed to bring instruction as to the steps taken upon the respondent number 4, 5, 7, 12.
Yes.
So, in this regards, Lordship, I have filed one additional affidavit whereby we have stated that, Lordship, this notices have been served to all of them, Lordship.
Okay. Notices have been served.
Served, Lordship.
Okay.
And out of them, 2 already expired, and 5 persons already retired, Lordship.
In that case, my lord, since the notices are complete, matter may be listed for admission after a week, since it is a long pending matter, so just 1 week.
You are for the respondent, no?
I am for the respondent.
Okay, you have received the notices.
There was an order from this honorable
Uh-huh.
court that since the respondents are working under him.
Okay. So, all right. Learned Counsel Ms. N. Dangan
Yes,
is present for the appellate. Learned additional double AG, no?
Lordship, I'm senior government.
Senior government advocate, Mr. N.
S. Tapin.
S. Tapin is present
For 1 to 3, Lordship.
for the respondent number
1 to 3.
1, 2, and 3,
Lordship.
and has submitted that an affidavit has been filed stating that notices have been served to respondent number 4, 5, 7, 12, 13, 15, 23. No, 20, then 23, 24, 26, 27, 28, 30, and 33. As the respondents are working under the authority,
Lordship, they are working under police department, Lordship.
under the forest department, full stop. As affidavit. Where is the affidavit page?
Lordship,
Running page?
it starts from 423, Lordship.
423.
423. Different, separate. यहाँ तो नहीं है.
Okay, very sorry. Okay, thank you so much.
ये कॉपी सब रहना चाहिए.
Notices are hereby deemed to be served on the aforementioned respondents. As pleadings are complete, list this matter for admission after 1 week, 2 week,
1 week.
1 week. Okay.
Item number 2.
May I please, Your Lordship? Appeal, my lord, against conviction under 302, 201. My lord, this is by Sessions Court Bomdila. Judgment is at page 99 of the paper book. Judgment dated 30/4/21. The sentence is life imprisonment, out of which 10 years would be rigorous imprisonment, along with a fine of rupees 5,000.
He's behind bars?
Yes, my lord. This was initially filed as a jail appeal. Later on, they've engaged me. FIR is, my lord, at page 1.
There are two paper books here.
Yes, since it's a voluminous one, they have,
How
it's a
many
continuation.
witnesses?
My lord.
How many witnesses?
Witnesses, my lord, 17.
Will you
Uh,
be able to conclude today or within tomorrow?
Hopefully today, my lord.
Hopefully.
Yes.
Huh?
Lord, it won't take much time, my lord.
Okay.
It won't take much time, my lord. And it's bulky because, my lord, the second part of the paper book is just the judgment. Most of the paper book is judgment only.
Judgment.
This is the relevant one, the only the first volume one.
Okay. Because you see, I have a limited time here.
Yes, my lord.
So it has to be completed before I leave.
Yes.
Tomorrow, my lord, it's not be possible for me, but today I'll try to conclude.
Okay. Today you'll try to conclude.
Yes, my lord.
And if you won't be able to conclude, then tomorrow it won't be possible.
My lord, I have prior
Tomorrow
engagements
just
tomorrow.
will not, actually we will not will not go further from today. DB, we have only one more day today, only one day
My lord.
today. From tomorrow, I'll be having the single bench.
I will try to conclude. I cannot speak for them, of course.
So he will conclude. According to him, he will conclude. But what about you?
In that case, my lord, next date may be given. Tomorrow,
It
I'm
will be better.
Yes, my lord, that will be better, man.
Yes, because if you are not sure, then it's better not to proceed because from tomorrow I'll be sitting in single bench and then this is a voluminous case.
It's a fixed night, and it can okay.
of course, my lord, not
As in
all.
behind bars, we'll give you a fixed date.
Yes, my lord.
My lord, after my lord vacation, this winter break, my lord.
That'll be too
No,
long, my lord.
I think that will be because he's behind bars.
My lord, if it can be on 8th of December.
8th of December, yes.
ठीक है, okay.
8th of December, my lord.
8th of December, yes. I'll take it on me. List this matter on 8th of December.
Yes, man.
Oblige.
Oblige, man.
Yes.
I look section 32 and 33. This has come on by orders on mention.
Yes.
On being mentioned. This matter came up on the 3rd of November. It was admitted for hearing. This was supposed to be discussed after 3 years, three weeks. Now, without, despite being only 2 weeks, he makes a mention and gets it reset. The 3 weeks has not expired. This type of practice cannot be allowed.
Maybe he has some urgency.
In that event, they have to file an application, not by making a mention.
All right, I have considered to my friend, matter may be fixed, on the
That's
second
not-
second week of the
may be
December.
fixed as per the last order.
week of the December.
Because this will amount to reviewing the earlier order.
31 and
My-
32?
Yes,
32 and
31 and 32. My friend is not very, it is all right. Yes,
32 and 33.
32 and 33.
32, 33?
Yes, maybe on second week of December,
Okay.
Yes.
second week. The first
As the
week of
matter has been
first
fixed
week of
for
December.
to be listed after 3 weeks,
Yes,
list this matter,
first
Last order.
As per the earlier order dated, when was the earlier order?
It was,
1st November 2020.
As per the earlier order dated 3/11/2025.
last.
Yes, yes.
But let's mention item number 3,
Mm,
on behalf of Standing Council for Education, Sitaru,
mm.
with the consent from other side, this matter will be fixed on 3rd December.
Okay. Item 3. On behalf of learned counsel, Mr. T. Tagum, with the consent of the other side, list this matter on.
3rd December.
Prayer has been made to list this matter on 3rd of December. List accordingly.
And Lordship, there are some other items, on behalf of, Standing Council,
Mm.
20 and 22.
On behalf of standing counsel, T. Tagum,
Yes.
and we have taken the consent of the other side.
I have not, in fact, in item number 20, we have to file counter affidavit.
Okay.
Parawise comment has not yet been received, therefore, for filing counter affidavit, this matter will be.
Prayer for adjournment has been sought on behalf of learned standing counsel, Mr. T. Tagum. Standing counsel for what? Education.
Education
And consent has been taken from the other side. List the matter
after 2 weeks.
after 3 weeks. Okay.
And also 22.
Yes, yes, both 21 and 22.
Big deal.
Same order in both the cases.
And in fact, Lordship, item number 12 and 13 also I have not taken, but then this is.
Consent has not been
Yeah,
taken.
this is also the,
For T. Tagum,
yes,
he's out of station.
yes, he's out of station.
Your name?
Arkoyu.
Learned counsel, Mr. R. Koyu, on behalf of Mr. T. Tagum has submitted that learned standing counsel education.
Education
Mr. T. Tagum is out of station. List the matter
after 3 weeks.
after 3 weeks.
Big deal.
Yeah, my lord. My lord, I beg to mention item number 18, my lord.
18.
Yes, my lord.
Yes.
My lord, as per the earlier order, my lord, we have to take the fresh step upon respondent number 5 and time to file, take the step, Your Honor.
Learned counsel, Mr.
NUB, my lord.
N,
UB.
item number 18, no?
Yes, yes, ma'am.
NUB has prayed for adjournment to submit, to take fresh steps
Fresh step.
against the respondent number
5 and 6, ma'am.
5 and 6. List the matter after 1 week,
3 weeks, my lord.
list the matter after 3 weeks.
Obliged.
But this year,
Yes, yes.
Lordship, I beg to mention item number 10 and 11 also.
Hmm.
Lordship, this is a joint prayer, Lordship. Kindly this matter may be taken up after 3 weeks, Lordship.
Learned counsel, Mr.
D. Lona.
B. Lona, for your name is not.
Appearing on
found.
behalf of Mr. D. Pangin, Lordship.
B. Lona on behalf of learned counsel, Mr. D. Panging, with the consent of the other side, has prayed for adjournment. List the matter on
After 3 weeks.
after 3 weeks.
Lordship.
Project to mention item number 31. Fine for respondent number 4. This matter will be kindly fixed on 2nd of December. This is with the consent of the other party.
Your name?
Yes.
Learned counsel, Mr. J. Sering, with the consent of the other side,
Yes, madam.
has prayed.
I'm for the,
adjournment.
I'm for the petitioner here.
You want your name to be recorded?
Please ring here, my lord.
Learned counsel, Mr. T. Sering, with the consent of the other side, has prayed for adjournment. To stop, learned counsel, Mr. T. Sering is present on behalf of the petitioner. List the matter when
2nd of December, my lord.
on 2nd December.
Obliged, ma'am.
Ma'am, I beg to mention item number 6 on behalf of N. Anju.
Mm.
Due to some, on behalf of N. Anju.
On behalf of N. Anju, adjournment has been sought
Yes,
with the consent of the other side.
yes.
List the matter when do you want?
3rd of December.
On 3rd December.
I beg to mention one more item, item number 15 and 16. Here I'm from petitioner. We are filing affidavit in reply
Hmm.
today, so maybe fix matter after 2 weeks. 15 and 16.
Learned Counsel Miss
S. Somo.
S.
Somo.
Somo has prayed for adjournment as, what was the ground?
We are filing affidavit in reply.
As they are, as they have, they'll be filing affidavit in reply.
Today, yes.
Today.
Yes, Your Lordship.
List the matter after
2 weeks.
2 weeks. Today, no required. They'll be filing affidavit in reply.
Much.
I wish to mention item number 4 and 5. Leading main counsel for the petitioner is come from the Guwahati. Today he is
Okay.
matter will be,
Absent.
yes, matter will be fixed on 28th of this month.
Adjournment has been sought on behalf of Learned Counsel Mr. H.K. Das.
SK Das, yeah.
Please the matter.
On 28th.
Okay. Consent you have taken?
Yes.
No point of
Yes,
taking.
I have
consent, he
taken
has not come.
I have taken
Consent has been taken from the other side. List the matter of
28.
28
Yes, sir. Of this month.
28 of this month.
Yes.
Okay.
What was that to mention? Item number 29 and 30. Consent have been taken from the other side. I'm mentioning on behalf of N. Pada.
Adjournment has been sought on behalf of Mr. N. Pada with the consent of the other side.
No,
List the matter after
Lordship, 3 weeks.
3 weeks.
Yes.
Okay.
Deeply obliged.
I mentioned 2 items, for tomorrow, only for fixing a date, this order.
Possible, no? Tomorrow? Tomorrow.
Yeah, sure, Lordship. Item number 1 and 2.
Please, Your Lordship. Lordship, this matter today was listed for disposal of the matter, Lordship. But it seems opposite party in the CRP is out of station. So in the writ petition, I am representing the petitioner, Lordship. Since writ petition is clubbed with CRP, that in the writ petition, I am the petitioner, Lordship.
Here you are the?
I am the petitioner in item number 1. Item number 1, I am the petitioner.
Okay.
In CRP, they are represented by other councils.
In both the cases, you are the petitioner.
No, my lord. In CRP, I am.
Then we'll take one by one.
Lordship.
Pass order separately. then.
Lordship. Since it is clubbed, so
Since this is clubbed together, this may be taken up together. Since the
Same date, we'll fix the same date, but I'm getting confused a bit. Let me see the item number 2.
Lordship, what had happened is, Lordship, during the pendency of this CRP, the impugn order which I have challenged in WPC was passed. So I have assailed that impugn order by the arbitration board in my writ petition, Lordship.
Okay. You are Pakjen Puchung.
Yes, Lordship.
Okay.
So also this has been clubbed together along with the CRP, Lordship.
My
So orders are passed together in both.
Lordship, my sole ground in the writ petition is I am contending that since the CRP is pending, in the CRP parties are same. During the pendency of that CRP, I have informed the authority concerned about the same pendency of the CRP before this honorable court. In spite of knowing that fact, the impugn order which I have challenged in WPC.
The other party in the other case. Orders are passed together.
Order
We
can
keep
be
the
passed.
same date and
Lordship,
keep it
Lordship,
together, but
Lordship.
we have to pass separate orders.
Lordship.
Because the parties are opposite.
In CRP, parties are otherwise in WPC, I am ready, Lordship.
CRP, Lordship, petitioner is not here, Lordship. This matter may be clubbed together.
Sorry.
Let's maybe list some other developments.
Okay, then both the cases. Learned Counsel, Mr. Jejini
Lordship, JJ.
is present. For Pakjen Puchung, comma, Taku Puchung, and Bojung Puchung, full stop. Learned government advocate, no?
Lordship.
For
One and
Miss
then two. Huh?
Miss Theatre.
One and
Theatre, no? Miss Theatre is present for the for 1 and 2 lordship. Correspondent number 1 and 2. In WPC. Okay. WPC 130 lordship. Correspondent number 1 and 2 of WPC number 130 AP 2021. Whereas, the Learned Council for Tame Pupur is not present today, no?
Lordship, we have taken steps, Lordship. In fact, to that effect, we have filed one affidavit also, Lordship.
Tame Pupur, no?
Lordship.
He's the petitioner in the CRP.
Yes, ma'am.
Tame Pupur is not present today. It is submitted that steps have been taken and notices has been issued to Tame Pupur.
Lordship, there is one additional affidavit we have filed, Lordship. To that effect, there is an order also, Lordship. I don't recollect that order, Lordship.
Okay, then
It
the
was-
last line is not required. It's not present today. You are for
I am for petitioner side in item number 2, my lord.
petitioner? Item number 2
Yes,
in CRP.
in CRP, my lord. Civil revision, my lord, item number 2, my lord.
Then you'll have to delete that order. Learned Council for Tame Pupur is not present today. We'll have to delete it.
No, my lord.
You are present for Tame Pupur.
Yes, my lord, the leading council is our second, my lord.
Okay. It's not present today. It's okay. List this matter then. When do we list it?
2nd of December, Lordship. Can it
List
be?
this matter on 2nd December, okay? All right.
Lordship.
Item number 7.
My lord, today I want to place my case, my lord. My lord, I had been appointed. My late husband has been appointed as an LC in the year 1976 in the office of SLC. ALC is a labor in the year 1976 in the office of Additional Deputy Commissioner Pasigat.
Okay.
And he has been working as a LC till 1987. And in 1987, his post has been transferred to the in the department of RWD, and wherein he has been appointed as a chokidar in the RWD guest house, Rukshin. It's a casual labor. It's chokidar and casual labor.
Okay.
And till he has worked as a casual labor in 2008, where he has been permanently absorbed in 2008 as an sweeper. His permanent appointment has been made in 2008
Okay.
as a sweeper. Thereafter, in the year 2017, he expired.
Yes.
But case was that his casual period of service has not been regularized, though he has been permanently appointed, but his casual labor period of casual labor has not been regularized. So this matter has been later there are many communication letters of executive engineering of Pasigat to the chief secretary.
Just a moment, yes.
I'm sorry, Lord.
I think he has some benefits for you.
Was not aware that Lordship, the department has filed the affidavit
Hmm.
because the matter is pertaining to the RWD department.
Hmm.
My friend is sending counsel for the RWD department.
Hmm.
And he was supposed to file the affidavit.
Hmm.
He has already filed, but the copy was not given to me.
Hmm.
And just now I have perused the affidavit.
Hmm.
It claims Lordship, it's found that Lordship, our our affidavits is contradicting to each other.
Okay.
So I may be given at least 2-3 days Lordship or 1 week Lordship. So I'll discuss with the
Yes.
authority.
And then if possible, then you can give the benefits also.
Lordship.
Possible.
Lordship.
Because
That part Lordship will work out
I
because
think it has to be.
department
included.
cannot contradict each other. Lordship.
Yes.
The one government. Lordship.
Yes.
I have also filed the reply to the affidavit filed by the respondent number 225.
Time.
Hmm.
I think your matter will be taken up and I think your benefits will be given. This is what I presume. Please give them.
A week time Lordship.
Hmm. Learned Council, Government Advocate Mr. S. Tapin has prayed for time to go to
It's
the,
just copy chair.
recently filed affidavit
Lordship.
by the which department?
RWD. RWD.
By the RWD. Full stop. List this matter after, list this matter on
After a week close.
after 1 week, shorter date,
Fixed date may be given, 8 or 10 of December.
8 or 10?
No issue, Lordship. 10 December.
10
Sorry,
December.
8
8 December, okay.
Obliged.
Item number 8.
My lord, may I pray for the Passover since the council is in another court?
For the time being,
Yes, ma'am.
after some time then.
Item number 9.
On last occasion, the respondent are short time to file affidavit,
Hmm. But today they are not here.
not yet. So, your, my lord, last chance may be given.
Learned Counsel Mr. O Modi
Yes, ma'am.
is present for the
Petitioner.
petitioner, whereas the respondents are not represented today despite time accorded to them to file affidavit, counter affidavit, full stop. A last chance is accorded to file counter affidavit. This after 1 week,
Yes.
2 weeks maybe. It has to come up in the notice board also. Cause list timing.
Okay.
Item number 14.
Same case,
No, my lord,
same parties.
not same party. Here also, my lord, respondent are given time to file the affidavit.
Lordship, I'm preparing for 1 to 4, all the
Supposed to
responses.
file affidavit, I believe.
Yes, Lordship, we'll need some time to file our affidavit, Lordship.
Yes.
We have no instructions.
Short that may be.
Sorry.
Deputy.
Learned Counsel Mr. O Modi is present for the petitioners and learned Government Advocate Ms. S. Sangeeta.
P. Sangeeta, Lordship.
P. Sangeeta is present for respondent number 1 to 4 and has submitted for time to file affidavit.
3 weeks time, Lordship.
3 weeks time to file affidavit in opposition, full stop. This after 3 weeks.
Obliged.
Item number 17.
My lord, I'm appearing on behalf of Deepangan, the leading counsel for the petitioner. In the last occasion, we have taken steps upon respondent number 6. However, the service could not be completed. Kindly allow us to take fresh steps.
You want to take fresh steps?
Fresh steps.
Only respondent number 6 is not represented. Others are represented.
Yes, I'm for 1, 2, 3, and 5.
Both the parties are represented except respondent number 6. Full stop. Service report on respondent number 6 is awaited. First steps may be taken to issue notice to respondent number 6, returnable within 3 weeks. 3 weeks will be returned. List accordingly.
Obliged.
Obliged.
Item number 19.
This matter, my lord, can be listed after 3 weeks, my lord. I need to take instruction from my client also, my lord, in this case.
You want some time?
In
Learned
read,
counsel, yes.
in read petition,
No
also.
objection?
No, Lordship.
Definitely. You won't have any. Learned counsel, Mr. L. Parme, has prayed for time as he has to obtain certain instructions from the petitioner. Learned counsel, Mr. Government Advocate, Senior Government Advocate, Mr. S. Tapin is present. For respondent, all the respondents,
Also,
Sole respondent.
for the sole respondent, lists after
3 weeks, my lord,
3
3.
weeks.
Obliged.
Item number 21.
Pardon, my lord. There was an interim in item number 17.
Okay, item number 17, interim order shall remain in force till the next date of listing.
Obliged.
May my lordship,
Hmm.
some instruction was sought for, but we haven't received our instruction. So this matter will be taken after 2 weeks.
Any problem?
Lordship, there was in the last order, the entry was to be granted in the next,
After 2 weeks, I'll take.
because the functioning of the organization is at the worst now. They are violating all the provisions.
See, due to some, I think, maybe there are certain conditions, prevailing conditions why interim was not granted in the last order. So I won't go there. Let us grant her 2 weeks time.
Oh, Lordship. Most of that.
Learned counsel, Mr. T. Tatak
Tita.
is present for the petitioner, and learned government advocate, Ms. K. Wangmo,
Yes.
no? Is present for the, how many respondents?
1, 2, 3.
Respondent number 1, 2, and 3, and has submitted that also that instructions could not be obtained, and has prayed for time to obtain instructions. List after
2 weeks, ma'am.
2 weeks is fine.
Okay, it's so.
List after 2 weeks.
Most of that.
Item number 23 and 24.
Very near.
I know. Dear Lordship, in item number 24, I am appearing for the private respondent, Lordship. So I need some more time to file my affidavit, Lordship.
In WPC, learned counsel, Mr.
K lawyer.
K. Lawyer has prayed for time to file affidavit in opposition.
Yes, Lordship.
Full stop. Affidavit in opposition in WPC number 121 of 2024. দুইটা আগলা ক্লাব করে লিখি দিবা. The applicant is not represented. Okay.
Apologies, Lordship. I was there at court number 2.
It's okay.
May I please, Lordship. Lordship, the applicant petitioner, we have filed this IA seeking direction from this court for directing the respondents to stop their illegal cutting that is going on currently in the disputed area, Lordship. So that's why we have filed this IA.
I have not yet received the copy of the ILOC.
Lordship, we will serve them today itself.
But if you keep on cutting, then we're
Yes, Lordship. That is why we are praying for interim.
infectious.
Yes, Lordship.
Lordship,
And
then
they
I
have
have
been
to
doing
take
this
instruction from the client.
The copy now.
today itself. Yes. Today itself.
Then when will you submit? After the copy is furnished tomorrow?
Next week,
Tomorrow.
Lordship.
Lordship, tomorrow.
Next week, Lordship.
Next week.
Next week will be too long. They have been cutting trees for more than 1 year. We have already filed 2 complaints before the Machuca police.
1 year.
More than 1 year.
Okay, on Monday then. On Monday.
Monday. Lordship, this Friday.
See, you ought to have given them the copies.
Lordship. We will do it. We will
In
take-
fact, Lordship, it is the petitioner who is cutting the trees, Lordship.
No, Lordship.
We have also filed FIR, Lordship.
You will decide on Monday. Okay. What is your name?
E. Payang, Lordship.
Learned Counsel Mr. E. Payang is present for the applicant, and you are the respondent.
No, I'm the petitioner. I'm the applicant and the petitioner.
Applicant, President, stroke petitioner, Sri Pemba Sona.
Pemba Sona, Lordship.
Full stop. The Learned Counsel for your name once more.
K. Loya, Lordship.
Learned Counsel K. Loya has submitted that copies have not been furnished. Copies of the interlocutory application has not been furnished. Full stop. But the applicant stroke petitioner to furnish copies. Please during the course of the day. Let's just matter on Monday. Monday ki hobo? Monday 24. Okay. 24.
Deeply
obliged.
Item number 25 and 26.
May I please, my lord.
Yes.
My lord, this IA 284, that item number 25 I filed. And here in this application, we are praying for vacation of the interim order dated 5/9/2025 passed by this honorable court. Because in the writ petition,
Where is the interim order? Have you annexed with this?
yes, I am annexed.
Which page?
This is page 18. So annexer 1, page 18. Before coming to this order, my lord, I'll just narrate the facts, brief facts, my lord. My lord, this applicant company, my lord, was awarded some work, my lord, the hydroelectric project, my lord, development of the hydroelectric project at Italin in Dibang Valley district, my lord. Now, my lord, some employees, my lord, they expressed their willingness after we issued a circular. And those employees were posted, my lord, in that area. But my lord, since it's a very hard area, the company issued a circular again in 12/10/2023, saying that some special incentives are to be given, because since it's a very hard area. And in that special incentive, some special promotion was given. It was not a regular promotion. It was just an incentive as long as the petitioners or not the petitioners, the employees, my lord, are posted there in the hard belt, my lord, in that project site, my lord, just as an incentive. It's not a regular promotion, my lord. Because and under that incentive, my lord, one higher grade pay was given, my lord, to the personals posted there. Now, subsequently, my lord, there was an objection, my lord, by the audit, my lord.
This extra grade was given.
Given, grade, my lord. That higher pay was given, yes, as a special incentive, my lord.
Okay.
Now, there were some certain objections, my lord, because the Department of the Public Enterprise also, because this applicant company, my lord, it is a public sector undertaking, my lord. It's the undertaking between the Union of India and yes, and the government of Arunachal Pradesh or Himachal Pradesh. Now there were certain objections, my lord, because these payments, my lord, there was an extra irregular expenditure of around 22 lakhs by granting those special promotion. Now, keeping in view those circulars and the objections raised by the audit, man, the earlier incentive, special incentive was rolled back in July 2025. Now the writ petitioner filed a writ petition, this instant writ petition 427 of 25, on the premise that the special incentive that was given petitioners and other employees on and being misconceived that it's a regular promotion and they should the petitioner is still entitled to it. Basically, what in the writ petition, the petitioner is saying that he has been demoted by recalling that earlier incentive. So accordingly, that while issuing notice on 5/9/2025, that interim order was given that the subsequent that circular, it must not be given effect to the petitioner. So today I'm here for the vacation of this that interim order. This is at page 18, my lord.
Yes.
Annexure 1. It's a long order, my lord. Just the operative portion is
Yes, you can read the operative portion.
yes, my operative portion is at page 23, my lord. Yes, my lord. Subsequent to that circular of July 1/7/2025, subsequent order was given of the 11/7/2025, whereby the writ petitioner was brought to his original grade, my lord. That is 11/7/2025. Now, in the last paragraph, till the next date fixed, the impugn order dated 11/7/2025 shall not be given effect to insofar as the writ petitioner is concerned. Now, by that order 11/7/2025, since the first circular of 2023 was recalled and this new incentive was given effect to with from 1/7/2025, the subsequent 11/7/2025 order was passed, whereby the petitioner and other employees were brought back to their original post. Now this has been stayed in respect of the petitioner.
Okay, yes.
Your Honor, I'm appearing for respondent number 1, Your Honor, in IA. Your Honor, time may be granted, Your Honor. The Link Council is due to personal difficulties, he could not attend, Your Honor.
Would have said it earlier.
Yes, Your Honor. My sincere apologies on that, Your Honor.
Okay, then you have any objection? How much time? Because
Your Honor, fixed date may be given, Your Honor, on 24th of this November.
24th.
you are for a company?
Yes, I'm for the company.
Yes, you can afford to allow some time.
Yes, and they are asking for 24th
of this November, Your
Learned Counsel, Mr.
K. Terry.
K. Terry has prayed for time to place his submission
Yes, Your Honor.
on admission. List this matter on
24th of November, Your Honor.
parties are represented. First of Likhilova. All are represented, no? Parties are represented.
Item number 27 and 28.
My lord.
Oh.
Well, this IA has been filed, my lord, for a direction to respondent authority, my lord, for carrying out reassessment and re-verification of my land and standing properties, my lord, which is being acquired for construction of road, my lord, in Siomi district, my lord. My lord, may
Your Lordship, notice may be issued at this moment, Your Lordship.
Okay. All right. Learned Counsel, Mr.
El Nosiman.
El Nochi is present for the petitioners and Learned Counsel DSGI.
No, Your Lordship. Government Advocate, Your Lordship.
You are what?
1 and 2, Your Lordship.
Your name?
Y. Riram.
Y. Rigam.
Riram.
Riram. Learned Counsel, Mr. Y. Riram is present for respondent number 1 and 2 and
Lordship, I'm for respondent number 3.
Learned Counsel, Miss
Y. Gao, appearing on behalf of DSJ M. Kato.
Learned Counsel, Miss on behalf of DSGI, Learned DSGI, Mr. M. Kato is present for respondent number 3.
Yes, Lordship.
Issue notices to the respondents, extra copies to be furnished, list after 4 weeks,
Yes, Your Lordship. 3 weeks, my lord.
3 weeks. Issue notices to the respondents returnable within 3 weeks.
Oblong,
Issue notice, issue notice returnable within 3 weeks.
oblong.
All are presented, then we can waive also, except, okay, you want the notices.
Yes, Your Lordship. Your Lordship.
You want the copies also,
Yes, Your Lordship. Extra copies, Your Lordship.
extra copies.
Item number 34.
Lordship, Learned Counsel Mr. Kato is appearing in another court.
Oh, we have one more matter, no? Time being?
Passover matter is there.
Passover for a time being, then both the time being matters will take after 2 days.
After 2.
Because 2 I will be here to, for the
Yes, yes.
video conferencing also.
Lordship, I'm for item number 8, Lordship.
Ah.
I was on like on another call.
That
Okay,
Passover
okay.
matter.
Yes, it can be taken up, Lordship.
Yes, can be taken.
Item number 34.
Time being.
After,
Time. Okay.
yes, Lordship.
Item number-
Yeah, after this also I can take up. This matter I can take up after this.
Yes.
Also.
May I please, Lordship? Lordship, in this instant writ petition, Lordship, the petitioner has challenged impugn order dated 16/11/2023, whereby the petitioner who was working as a multitasking staff was terminated from the service, Lordship.
16/11/23.
16/11/2023. However, Lordship, at this stage, Lordship, I have a very limited prayer, Lordship, considering that in the similarly situated cases, the Honorable Coordinate Bench of this Honorable Court has reverted back the matter to the respondent authority for.
Oh, that termination order of teachers.
Yes, Lordship. This is with regards to MTS and.
Yesterday also I have passed order, I think.
Yes, Lordship, similar, as many as 188 employees, their case has also been reverted back to
Your
the.
prayer is limited to
Lordship.
reverted back only.
Yes, Lordship. Since that representation has not been considered so far.
In the same manner, we'll revert it back.
Lordship. Just the respondent. No, same.
Learned Counsel Mr. A. Tata
Lordship.
is present for the petitioner. One petitioner.
Yes, Lordship. Was working as a multitasking staff.
Srimati Oyong Tatin,
Yes, Lordship.
who has assailed the impugned termination order numbers EED capital D hyphen 12015/5/2023. Okay,
Lordship.
dated 16/11/2023, issued by the commissioner within bracket education bracket close comma government of Arunachal Pradesh, whereby the petitioner was terminated from a service as multitasking staff within bracket MTS for short bracket close. Full stop. The petitioner was serving in the office of the government senior secondary school,
Basic.
comma, Pesing. Full stop. Now, at this stage, a limited prayer has been made that this case may be remanded, that this case
Yes, Lord.
matter,
Yes, Lord.
this matter may be remanded back for consideration in sync with
Respondent number 1. Representation is pending before respondent number 1.
Instinct nalage. 2, for consideration by the respondent number 1. As the representation by the
Lordship.
petitioner.
Your Lordship.
Dated 28/11/2023, praying for reinstatement is pending in the office of the respondent number 1.
Your Lordship.
Full stop. It is further submitted that in similar matter, in WPC number 638 of 2023, the petitioner's counterparts
Lordship.
Huh?
Lordship.
who have been terminated by the same order or
Same order. Some are same.
order.
Yes. Lordship, page 39, para 12 is the operative portion of the order passed by the coordinate bench.
had also filed representations before the respondent number 1 and this court in WPC number
638.
638 of 2023, filed order dated 7/11/2025 has remanded back the matter for consideration, matter to be remanded back the matter of 188 similarly situated petitioners to be considered by the commissioner, respondent number 1. You are standing counsel for education
No,
department.
I'm appearing on behalf of Titago.
Mr. R. Koyu, no?
Yes.
Learned counsel Mr. R. Koyu is present on behalf of learned standing counsel Mr.
Titago.
T. Tadu.
Tagum
T. Tagum
for education.
for the education department and has submitted that this matter may be remanded back and the petitioner's prayer for representation may be has fairly submitted that the matter may be remanded back and the petitioner's representation may be taken up by the respondent number 1 for consideration. I have to enake likhi diba. Upon perusing next para the materials and after considering the matter, it appears that based on the limited prayer, this petition may be disposed of as submitted by the learned counsel representing both the parties. Full stop. Next para, accordingly, the respondent number 1, being the learned commissioner and secretary, education department to the government of Arunachal Pradesh. Okay. Respondent number 1 is the commissioner, no?
Lordship.
Shall take up for consideration the petitioner's case and conduct the necessary verification regarding the nature of the appointments and based on the outcome of such a process, pass necessary speaking orders, as per law and also considering the aspect of parity with similarly circumstanced persons. Full stop. The petitioners may submit a copy of this order before the respondent authority. Full stop. In terms of the above observation, this petition stands disposed of. Anything else you want me to add?
Lordship.
Similar order may be passed in item number 9.
9? 9, I think.
Oh, no.
This
9, I think.
This different.
I thought like he
No, just a single. Deeply obliged.
Okay. Item number 34.
No.
Please, Your Lordship. I'm sorry, my lord, I was in
It's okay.
subject to my lord, lordship convenience. If matter is disposed of, my lord,
Can be disposed of if you are agreeable and if it won't spill over for 2 or 3 days.
no, issue is very simple, my lord.
More than 2 days, I cannot take up the matter.
Yes, madam.
But
Yes,
one day, within 1 day, yes.
Yes, madam. My lord, the issue before your lordship is very simple. What they are submitting is the suspension order was not reviewed as because I was inside the custody. But what I'm submitting is, my lord, as per the law, as per the, my lord, the CCS rules, my lord, suspension order has to be reviewed before the expiry of 90 days.
Yes, has to be reviewed.
Yes, madam. That is the issue, my lord, core issue. So therefore, my lord, without taking much time, my lord, I'll take your lordships to the impugned suspension order. I'll cite, my lord, the CCS rules relevant, CCS rules, rule 10 and sub rule, my lord, 5 and 6 and 7 also, my lord. And as per that, my lord, it is very clear. There is a provision, of course, my lord, NBC is under the rule 7 provided that the detention period. However, my lord, as per the
You
decision,
have the CCS?
yes, my lord. Even we, my lord, we have the copy, my lord. And that has
I
been,
think there is a book on
yes, my lord,
CCS with this.
Central Civil Service Rules, my lord. Before coming to that, my lord, just I'll, my lord, my lord, narrate the brief facts, my lord. The petitioner was arrested in connections to some police case, my lord, and he was arrested, admittedly, and subsequently, my lord, the suspended, my lord, by the order dated, my lord, 2nd June of 2024, my lord, Annexure 1. My suspension order is 2nd June 2024, my lord.
2024.
Yes, my lord.
Annexure 1 page.
Page number, my lord, 18 of my read petition, my lord. Thereafter, my lord, I was inside the custody, my lord, admittedly, I was released on interim bail. Thereafter, my lord, my bail was regularized, my lord. And that is another aspect, my lord. Thereafter, after my released, I intimated to the authorities concerned for my lord, my reinstatement in the service by revoking the, my lord, suspension order, my lord. That was not considered. Thereafter, my lord, I filed an RTI application before the authorities concerned. Why suspension is not revoked even after the expiry of, my lord, 90 days. Thereafter, my lord, again, another, my lord, the information which I sought for was, my lord, whether there is any charge, memo of charge.
Suspension not revoked, it will be reviewed.
My lord,
After 90 days.
90 days, it has to be reviewed.
And then it has to be extended.
Extended, not beyond the 180 days. That is correct, my lord. That has not been done, my lord. Now, my lord, that is my simple case, my lord. Now, my lord, by another, my lord, when, my lord, may kindly know, this case was filed on 1st May 2025, my lord.
This case.
This read petition, my lord, present read petition. And, my lord, my lord, the reviewed was done on when this court has issued notice to the respondents on 3rd.
All right. This case was filed on 1st May 2024.
Correct, ma'am.
2025.
Yes, ma'am. 25.
And then thereafter, this order was reviewed.
Reviewed.
And extended.
Extended, ma'am. Reviewed was done on the when, well, notice was issued by this honorable court on 3rd June 2025, madam. Reviewed was, madam. They have, madam, filed also, madam, the affidavit in opposition by which, madam, they are showing that review was done on 3rd June 2025, madam. So, madam, by that time, altogether, from first day of effective suspension to the date of expiry of 90 days is, madam, altogether 276 days, madam. From the date of effective suspension to the date of expiry of expiry of 90 days is 270 days delay malan. And from entire date of effective suspension, Lordship has seen 2nd June 2024 to till the review of the suspension order is altogether 366 days malan. As per their own notification issued by the state government, there is a standing notification. In any case, review has to be done, and that has to be strictly done before the expiry of 90 days period, as per the CCS rule. And suspension is again not beyond the 270 days. Even if if person is inside the custody or something else, when that has to be in force for a period of not beyond 270 days. In case, even if the review is counted from the date of initial suspension, it is counted as 276 days, Lordship has noted, and total period of suspension is
1 year.
366 days, 1 year, exactly. So therefore, suspension order, the initial suspension order is required to be interfered with, and direction may be issued to the state respondents for my reinstatement. Now, I'll bring to your Lordship the attentions on the relevant rules, CCS rules, Central Civil Service rules. What they are harping is state government, of course, my learned friend will explain. However, as per what they are harping is as per Rule 7, sub Rule Rule 10, sub Rule 7, proviso, wherein it has been provided that.
Yes.
Just for a moment, may I take your Lordships to, as Lordship has already pointed out, just to sort in the time, I'll just take your Lordships to the Rule 10, sub Rule 6,
Sub rule 6, no? Yeah.
Sub Rule 6,
Yes.
Lordship has been. I'm reading sub rule 6, An order of suspension made or deemed to have been made under this rule shall be reviewed by the authority which is competent to modify or revoke the suspension. No, before expiry of 90 days from the effective date of suspension, on the recommendations of the review committee constituted for the purpose and the past orders, either extending or revoking the suspension. What they have to do is either it has to be reviewed, either it has to be revoked. That is the first line. Subsequent review shall be made before the expiry of this is another before the expiry of extended. Say suppose 180 days is extended, before the expiry of 180 days, extended period, before expiry of the extended period, it has to be again reviewed, and another review of suspension. The extension of suspension shall not be a period exceeding 180 days at a time. This is the ceiling limit. At the time, the review can be done up to 180 days, and that extended period is to be again, if it is required to be reviewed again, that will be not beyond 180 days. And in any case, before the expiry of 180 days, review has to be done. Now, this is clear provision. The another provision, this is the contentions of the respondents. Either Rule 7, an order of suspension shall not be valid after a period unless it is extended after review for a further period before the expiry of 90 days. In any case, it has to be reviewed before expiry of 90 days. Otherwise, that will valid invalid. That will not valid. However, my lord, the proviso has been given, my lord. In this proviso, my lord, what they are contending is by taking this particular provision, my lord, provided that no such a review of the suspension shall be necessary in the case of deemed suspension under sub rule 2, if the government servant continues to be under suspension at the time of completion of 90 days of suspension, and 90 days period in such case will count from the date of government servant detained in custody is released from the detention, or the date on which the fact of his release from detention is intimated to the appointing authority, whichever is later, my lord. My lord, by this provision, my lord, admittedly, my lord, detention, if the person is detained, my lord, from the release of his detention has to be intimated to the appointing authority. Yes, I'm released from the custody, so therefore my lord, the suspension may be considered and reviewed, and maybe my lord, the reinstated in the job, my lord. That is the, my lord, the clear contention of this line, my lord. However, my lord, this was amended. This was of the, my lord, this particular subsection, sub rule 7 was, my lord, incorporated in the year 2000, my lord, 2007, my lord. My lord, what I'm respectfully submitting is this has to be actually modified after the, my lord, the judgment of the Ajay Kumar Chaudhary case, my lord.
Yes.
In Ajay Kumar Chaudhary case, it has been clearly decided. Just for a moment, my lord. If lordship is having the
You have the book, Ajay Kumar Chaudhary?
my lord, it is of 2000. I've quoted also in my read petition, my lord.
You have the book? Yes.
My lord, list of citation has been provided.
List of citation has been provided, I think.
Just now only they have provided.
Oh,
That's why. They should have provided in the morning before the course.
True, my lord. Just for a moment, my lord, if lordship, if I read, my lord, lordship will clearly understand.
Yes.
Otherwise, my lord, it is reported in 2015, 7 SSC, my lord, page number 291, my lord. And relevant paragraph is, I'll not go into the, my lord, the entire details.
Which paragraph?
Para 21, my lord. We therefore, my lord, just I'm reading, my lord.
Yes.
We therefore direct that the currency of a suspension order should not extend beyond 3 months. 3 months is 90 days, my lord. If within the period, if this period of if within this period the memorandum of charges or charge sheet is not served on the delinquent officer or the employee, my lord. Exactly, this is my case. Well, so far, as I have categorically stated in my read petition also, my lord, so far no memorandum of charges is framed against me, my lord. And even in their affidavit also, they are not disclosing that memorandum of charges has been framed against me, even after, my lord, the expiry of this 90 days. Oh, sorry, my lord, 366 days, my lord. Till today, my lord.
That DPC has not framed memorandum of.
No, my lord, nothing. I'm still under suspension for, my lord,
1 year.
more than 1 year now. My lord, I'm reading continuously reading, my lord. Delinquent, if, my lord, I'm reading, therefore, the direct that the currency of a suspension order should not extend beyond the beyond 3 months if within this period the memorandum of charge sheet is not served on the delinquent employee officer. If the memorandum of charge sheet is served, a reason order must be passed for the extensions of the suspension period, my lord. As I have pointed out, not memorandum, nothing, my lord, till today, my lord. As in this case, in hand, the government is free to transfer the concerned person to any department my lord, I'm sorry, my lord. Any department in any of its officers within or outside the state, so as to serve any local or the personal contact that he may have in which he may misuse or obstructing the investigation against him. The government may also prohibit him from the contacting any person or handling the records and the documents till the stage of the having to prepare his defense. We think this will adequately safeguard the universally recognized principles of the human dignity and right to speedy trial. I'll not go that part. This is the part which I'm relying.
Para 21.
Para 21, first line, it has to be, in any case, it has to be reviewed before the expiry of 90 days, And another, judgment,
You can give me the printouts. That will be better. No, I'm telling her she can give me the printouts. That will be better.
I'm sorry.
Instead of the entire book.
Yes, ma'am.
Actually, usually we used to request the advocate when they come, they give late, then they should give the with the citation. Otherwise, before the court starts, we used
No,
to
no,
tell
it's
them.
okay. Later you can give me the printouts.
Yeah, sure.
Later.
Just I'm
After this case is over.
just I'm placing reliance on the judgment. Now, another judgment is of our own High Court, It is 2025 3 GLT 485 rendered by His Lordship Justice S. Soikia In that paragraph, it has been clearly mentioned, even if the continuous detention is there, in any case, it has to be reviewed before the expiry of 90 days. This has been clearly laid down by His Lordship.
Party's name?
Party's name is Santosh Kumar versus Union of India, decided on 6th March 2025, latest one. And after this, I have not gone through any judgment that this has been modified. It is in writ, of course, writ petition will be not required. In para 10,
Para
10
10 of the judgment.
judgment,
Okay.
and para 12, para 14,
Para 10, 12, 14.
yes, madam. Para 10, 12, 14, 15, 16, 17, and 18, 18 and 19 and 20 is the directive, direction issued by the. Just for a moment, may I read,
Yes, yes.
Para 10, I'm reading, The disputed issues in the present case are whether the suspensions get revoked under the review of the suspension is made before expiry of the period of 90 days from the date of the order of the suspension, and also whether the suspension is required to be extended prior to expiry of 90 days. And this was the issues, And in that case, in such this issue, to proceed in the matter, it is first necessary to refer the CCS rules, which provides for the power of suspension and extension thereto. The Rule 10 of these CCS rules provided for the power of the suspensions to the appointing authority or the authority which is subordinate, or the disciplinary authority or any other authority competent empowered by the president. The Rule 7, and this is exactly what they are contending. Rule 10, sub-rule 7, provides under Rule 10, sub-rule 7, an order of suspension made or deemed to have been made under sub-rule 1 or 2 of this rule shall not be valid for a period of 90 days unless it is extended after review for a further period before the expiry of 90 days. This has been clearly laid down that even Rule 10, sub-rule 7 is required to be extended, though they deem the continuous detention, continuous suspension, but it has to be reviewed, as per the judgment of this honorable court, Now, after para 12, a careful perusal of the rules revealed that the Rule 10 mandates the categorically that an order of suspension made or deemed to have been made shall not be valid after a period of 90 days unless it is extended after review for a period beyond the expiry of 90 days. The rule therefore prescribes that any order of the suspensions must be reviewed and also be extended before the expiry of 90 days of the order of suspension issued by the authority. This rule came to be interpreted in a judgment of the apex court rendered in the Difal Mali Sufra, and this has been already referred, where the apex court upheld the judgments of the High Court of the Madhya Pradesh, which had interferes with the extension of the suspension order, and which order of the High Court came to be assailed before the apex court. The apex court, upon examining the entire matter as well as the CCS rules, categorically held that the review and the modifications or revocations of the order of suspension was required to be done before the expiry of 90 days. It is clearly laid down, 90 days from the date of the order of the suspension. And as had been categorically provided under sub-rule 7 of 10, the apex court held that the order of suspension made or deemed to have been made would not be valid after further period unless it is extended after review before the expiry of 90 days. Clearly mentioned, even if it is deemed suspension, it has to be reviewed before the expiry of 90 days. It is clearly mentioned. Now, para 13, the reference to the instant rule as well as the interpretations given by the apex court clearly lays down that the emphasis of the review as well as the extensions of the order prior to 90 days of expiry of the suspension order. But it is also clearly mentioned. Now, para 14, from the pleadings available on record, it is clear that there is dispute that the suspension order issued on 19/7/2019, putting the petitioner under deemed suspension until further orders. There is also no dispute on the fact that in our case also, it is they are not disputing that we are not under suspension beyond 180 days. There is also no dispute on the fact that the petitioner was taken custody on 19/9/2029, and therefore, under the provisions of Rule 10, Sub-Rule 2 of the CCS rules, the petitioner was deemed to be under suspensions by order dated 27 September 2019 until further orders.
We'll come back.
Madam.
You want to continue with reading, or I'll go through it myself? It's no.
Yes, just I'm referring what I'm relying on the.
Without the book also, it's
Yes.
difficult to concentrate on the.
I'm sorry, for that.
It's okay.
I instructed my juniors to place the citation.
I'll get the.
I have given to you.
Instead of the book, you just give me the printout. That will be better. Then I can, if it will be easier for me also.
Of our own High Court decision, it is very clear, even if it is deemed under suspension, even in that case also, Rule 10, Sub-Rule 7 has also been referred. Even in that case also, review has to be done. My contention of my friend is, as per the affidavit, which they brought on record, simply on that issues that since you are under deemed suspension, so therefore it is not required to be reviewed before the expiry of 90 days. That is the content.
Yes, I understand.
Otherwise,
come back after 5 minutes.
Just few minutes I'll
Yes,
take
yes.
to sum up the entire thing. As per this judgment, basically the suspension has to be done within a period of 90 days before the expiry of 90 days. And in that referred case, it is the same case. After the expiry of this 90 days, the review was done by extending another 180 days. This is exact similarly case. Even to Rule 10, Sub-Rule 7 is also referred. By even in that case also, my lord, 90 days before the expiry of 90 days, review has to be done. But in that case, my lord, time to time review was done, my lord. Now, my lord, what I'm praying for your lordship is, my lord, the impugn, my lord, once it is, my lord, not reviewed, that is automatically invalidated, my lord. Initial suspension order, my lord. That may be, my lord, interfere with and give with directions to the respondent authorities to consider my case by reinstatement and by following the subsequent, my lord, the service.
Direction, because I cannot revoke. They have to revoke.
Yes, my lord. Yes,
I
my
have to
lord.
give only.
Yes, yes, exactly, my lord. But I'm, my lord, submitting it.
Okay. All right.
Much of
Lordship, so far, law of that review is concerned, Lordship. In that regard, Lordship, there's no much dispute, Lordship.
Yes, correct.
But only the issue is, Lordship, from when, Lordship, that has to be calculated.
Mm.
That's very pertinent, Lordship. From when, Lordship, that 90 days has to be calculated, Lordship. Because 90 days has to start from somewhere, Lordship.
Mm.
In that context, Lordship, I'd like to take Lordship to the Rule 10 again, Lordship.
Yes, yes. I am at Rule 10 only.
Lordship. Rule 10, Lordship, sub-rule 7 says, Lordship, an order of suspension made or deemed to have been made under sub-rule 1 or 2 of this rule shall not be valid after a period of 90 days until unless it is extended after review for a period for a further period before the expiry of 90 days, Lordship. Now, so far, Lordship, the suspension in contemplations of departmental proceeding, because there are 3 situations under which suspension order can be issued, which is given in under clause 1, sub-rule 1, Lordship. If the suspension is in contemplations of the departmental proceeding, then the day when it's passed, Lordship, from next day it has to be counted, Lordship, from date of suspension, Lordship. But when it's about the deemed suspension, Lordship, because deemed suspension is the automatic Lordship suspension, Lordship, by virtue of the Lordship law that's provided under Rule 10, Lordship. Then, in regards to that, what the sub-rule 7 says, Lordship, from when the 90 days will be calculated, Lordship. In case of deemed suspension, here it is case of deemed suspension, not the suspension order has been issued in contemplations of the departmental proceeding, Lordship. The proviso to the Rule 7, Lordship, it says, Lordship, provided that no such review of suspension shall be necessary in the case of a deemed suspension under sub-rule 2. If the government servant continues to be under suspension at the time of contemplation, completions of 90 days of suspension, and the 90 days period in such cases will counted from the date of government servant detained in custody is released from the detention, or the date on which the effect of his release from the detention is intimated to his appointing authority, whichever is later, Lordship. Meaning thereby, Lordship, if after you have been released from the custody, Lordship, if you intimate to the authority, who is a competent authority, who has suspended you, Lordship, if it's intimated, Lordship, from the day of intimation, the day will be, they will start running, Lordship, 90 days, Lordship. The proviso makes very clear, Lordship, when the intimation about the release is intimated to the competent authority, from that day, Lordship, 90 days will start running, Lordship. That is the law, Lordship.
Yes.
And so far, whatever these citations has been placed, it's on this only, Lordship. 90, because after, if within 90 days, if review is not done, Lordship, then automatically in both the cases, whether it's deemed suspension or the suspension order, Lordship, that will be not valid, Lordship, after completion of 90 days.
According to him, even after deemed suspension, you were intimated. Then after intimated that you are released, that
I'm coming to that, Lordship. I'm coming because just I'm placing the legal propositions on this very point, Lordship. But what happened in the present case, Lordship? If I take to my affidavit file where respondent number 1 to 3, Lordship, kindly it may be taken up, Lordship. Respondent number 1, 2, and 3, Lordship.
Your affidavit starts from which page?
1 to 3, Lordship. Sorry, I'm sorry. It starts from 1 to 1, Lordship.
Okay. For affidavits are kept in separate files here in Arunachal. So we are not used to keeping affidavits in separate files. 1 to 1.
1 to 1, Lordship.
Okay.
Lordship, kindly come to paragraph, Lordship, 6, Lordship.
Paragraph 6.
Paragraph 6, Lordship.
He's an employee under the district judiciary.
No.
No.
He's in the police, Lordship.
Police, okay.
Kindly come to page, Lordship. Sorry, paragraph 5. I'll read the paragraph 5,
Yes,
Lordship. The by representation dated 21/1/2025
Yes.
was forwarded by letter dated 5/2/2025. It should be 25, Lordship. The department received the same on dated so and so, wherein the read petitioner sought for reinstatement of his service. Since the representation of the petitioner was a mere prayer for reinstatement without any further information on his custodial status,
Okay.
and the same could not be considered. However, by letter dated so and so, 3/3/2025, a communication has been received from the police headquarters that the read petitioner has been already released on bail by the order dated so and so. It be mentioned here that it is the first information that the competent authority had received on behalf of the read petitioner that he has been released on bail by the trial court on dated so and so. This is the communication dated, Lordship, 3/3/2025, Lordship. The past intimation in regards to his release from the custody. This intimation was received from the PHQ by the competent authority. The competent authority is the, Lordship, the Commissioner or Secretary of the Home Department, Lordship. And here, Lordship, intimation was received on a letter is dated 3/3/2025, Lordship.
Okay.
90 days, Lordship, if we calculate it, Lordship, it comes to an, is complete by 1st June, Lordship.
Okay.
1st June, Lordship. Then kindly come to next page, Lordship. That's paragraph 6. And before coming to that, Lordship, just I'd like to take Lordship to the annexure 1. This is the communication, which
page
127, Lordship. This is a letter dated 3/3/2025.
Yes. All right.
This is the communication from the assistant AIGP establishment, PHQ, to the Undersecretary Home. Undersecretary, we deem it because Home Commissioner is the competent authority to revoke the Lordship suspension. So this is communication to Undersecretary Home. Intimation regarding date of release from the detentions / custody in respect of Bulang Marik so and so. In reference to the subject and letter cited above, I am directed to inform you that the Bulang Marik Assistant Commandant 1st APPBN Chimpu was released from detention / custody with effect from 3/10/2024 by Special Judge so and so. The copy of interim bail order dated, interim bail extension order dated, and regular bail order dated so and so are enclosed herewith. By this communication letter, the competent authority received intimations about the release of the petitioner for the first time, Lordship. And from this date of intimation, Lordship, the 90 days has to be calculated, Lordship. Then thereafter, Lordship, review was conducted on 29 May 2025. That I have stated in paragraph 6, Lordship.
Okay.
That is within the period of 90 days, Lordship.
Okay.
So that's all, Lordship.
Okay.
Just to sum up, Even if review is done on before the expiry, the order has to be seen. It is not known when the review was done. It is the internal procedure. The committee constituted is sitting for the review or not. That is not the matter. But the order by which the extension is communicated, from which date it will be effective. It is the internal matter. They are having maybe meeting within the department. But the order was passed on 3rd June 2025 after expiry of 366 days. Exactly. Now, another thing is the ratio of the decision of the Honorable Apex Court as well as our own High Court, as well as the notification, standing notification issued by the state government. It is very much clear. It was issued on the 23rd January 2025. This is their own standing circular. Timely review of the suspension and early completion of the disciplinary proceedings. I'll skip entire things. Para 1, 2, 3, 4th line. Provided that. Provided further that in a case where no charge sheet is issued under these rules, charge sheet, memorandum of charges, article of charges, that has to be premed.
Yes, yes.
The total period suspensions or deemed suspension, particularly word deemed suspension is also used subsequently, simultaneously. As the case may be, including any extended period in terms of sub-rule 6 shall not exceed, as I've already pointed out, 270 days. 270 days in any case. Now, in my case, 376 days. I'm sorry, 276 days. It is prescribed 270 days, 6 days beyond. Now, another next page, para 2, it is clearly mentioned. Para 2, next page. In view of 1 above, 1 specifically referred 1. An order of suspension made or deemed to have been made shall be reviewed by the authority competent to modify or revoke suspension before the expiry of 90 days from the effective date of suspension on the recommendations of the review committee constituted for the purpose, and pass orders either extending or revoking the suspension. Subsequent review shall be made before expiry of the extended period of suspension. The extension of suspension shall not be a period exceeding 180 days at a time. Time and again, by this notification, it is clearly mentions that even if it is initial suspension, even it is deemed suspension, it has to be the review within a period of 90 days. That is the law.
So what is your prayer?
Malat,
Check the prayer.
another the intimation part, or admittedly, after my release, if it is clearly mentioned in my read petitions, ideally intimated, and that has been also received. And if from the date of intimation, admittedly, 90 days is not yet expired, but as per the ratio of the decision, in any case, it has to be reviewed before the expiry of 90 days. My period is, Lordship, it's para 14, I'm basically, for setting aside of the impugned suspension order.
It's an intermediary order. Because see, nobody knows if memorandum of charges have been framed.
No,
They also do not know if memorandum.
No, not yet filed, as I have pointed out at the very beginning, not yet framed, nothing, as because it is nothing to do with the department, as because the case related to some other issues, So it is nothing to, even if memorandum of charges,
Nothing related to the department.
Not department.
POSCO case.
POSCO case, admittedly, it is not related to the department. Because of that reason, since I am the employee of the same department, they are not taking serious action against me. But when this case has been instituted before this honorable court, they started thinking that yes, suspension has to be done from
So
the.
if I'll be counting the days. I'll be calculating everything, whatever you have said, whatever you have said.
Yes.
So if any anomaly is found, if it has exceeded the period, so I can pass an order that this order is not, I can pass the order that the review order is not according to law.
Correct, ma'am.
So then they will consider, I'll send it back to,
Correct, ma'am.
can I revert it back to consider?
Yes,
In
ma'am.
accordance with law?
Yes, madam.
Will that be appropriate?
In case if Lordship find that Lordship the
After
further
calculation-
extension is not as per the law, Lordship,
Yes.
then Lordship has to set aside the order itself, Lordship, the
Uh,
extension order.
That I,
And direction has to be given to the authority to reinstate the.
Fair enough.
They has to follow, Lordship.
Fair enough, madam. Even,
direction has to be given.
yes, ma'am.
State direction has to be given, Lordship.
Stop beating around.
Because extension has been held, if suppose say, if extension is held to be an illegal Lordship, then automatically the consequences has to be followed, Lordship. Consequential relief has to be given, Lordship. Then the authority has to be directed to reinstate the petitioner.
Fair enough, madam. Fair enough, madam. If extension is, madam, even if
That my submission, in case Lordship comes to a conclusion that Lordship, the extension is not as per the law, Lordship.
now, madam, another proposition is if extension, even if it is done, madam, the initial suspension has to be reckoned, madam. If initial extension, it is required to be done within a period of 90 days. Then if it is not done, madam, that will become invalid, madam, as per the decision of, madam, our own High Court, madam.
I'll go to the decision of our
Madam.
High Court and see. And if it is found in consonance with law, then what type of?
Then it has to be dismissed, Lordship.
Yes, madam.
It has to be dismissed.
Dismiss.
All right. Straight away it has to be dismissed.
No. There's not.
No midway.
No midway.
Madam, if therefore, madam, in my period, I'm madam, seeking for the setting aside of the initial suspension order, not on the madam, the substantial, madam, as I pointed out. During the pendency of this writ petition, the extension has been passed by the respondent authorities. So therefore, not we are on the madam, the extension. Extension is invalid as because within a period of 90 days, it has not been done, madam. So therefore, our failure is for interference of the impugned suspension order. If it is not reviewed, madam, as per this decision and the ratio of the decision of the Honorable Apex Court as well as the madam, our own High Court in Ajay Kumar case also, madam, it has to be madam, done in stricto sensu, madam, within a period of 90 days. Madam.
You are saying that earlier extent after this case was filed,
Correct, ma'am.
then they have reviewed
The madam.
and that is illegal.
That is illegal as well, and that has been done by madam, the respondent authorities after 366 days, madam, after 1 year, madam.
Okay.
It cannot be, madam, which I am submitting is. That's madam, shall I furnish the madam, or otherwise it will be available from the madam, library.
From the library. Or if no, it's okay. We'll get
Yes,
it from the library.
yes,
We'll download a copy.
Yes, madam, that will be more authenticated.
See, I'll work out on it in the
Madam.
afternoon. And if I have any doubt, I'll come back to you tomorrow.
Madam.
Otherwise, I'll dispose it off.
Yes, madam. Yes,
If I do not have any doubt, I'll dispose it off.
yes, madam.
No confusion, then I'll dispose it off.
Yes, madam. Yes. Much obliged. madam.
Circular dated 23rd January 2025.
Correct, madam. Even in the para 2 also, it has been clearly mentioned, even if it is deemed service, madam, the department is very fair enough, madam.
This is Department of Administrative.
Administrative reform, madam.
If I somehow miss a copy of this, I will ask for you again.
Madam, madam,
For
madam.
details.
Yes, I am having the extra copy. madam.
Circular dated. Let me see. If any confusion, then I'll come back to you. again
Madam,
tomorrow.
madam, basically our failure is, madam, para, madam, lordship may also go through.
Yes,
the-
yes, I'll go through the
Yes.
prayer. List over? Yes, matter is over. Please print this up.
Yeah.
And then those two judgments.
Much obliged.
I'm on the bed. Oh, yeah.